What's up, everybody? It's Jason Cruz here once again with another episode of The Legal Submission. And as always, I started off with telling you to subscribe to the YouTube channel, like the video, visit MMA Payout, subscribe to the Substack. It's all good stuff if you want to know the business and legal issues of combat sports. Now we're going to go back a little bit in time to earlier this spring to catch up on the Terence Crawford lawsuit against Bob Arum and Top Rank Boxing. Where we last left you, as you could see from the video that is asking you to click right now, you are in the midst of Top Rank moving this particular case to federal court. Top Rank filed a notice of removal to federal court from Terence Crawford's lawsuit, which was filed in Clark County, Nevada. Now, obviously, we went over the reasons for going to federal court as opposed to state court here. And so what has happened is that Terence Crawford is actually fighting the move to federal court by indicating that he is bringing a motion for remand meaning sending it back to state court because state laws overarch the issues related to the federal laws. In most cases, federal law trumps the state law issue, and you can go straight to federal court for that issue. For that reason, also with respect to a diversity of citizenship issue as well. Terence Crawford is a citizen of Nebraska. Top Rank is domiciled, or their place of business is in Nevada. So there is that particular argument. Crawford's arguing otherwise. Primarily the fact that the contract that it's based on relates to what is going on in the state of Nevada. So we pick it up with the Top Rank opposition for the motion for it to go back to the state of Nevada. And there are several reasons why a Top Rank wants this to be done, and this is outlined in their papers. So the arguments provided by Top Rank Boxing relate to just the civil procedure issues in this lawsuit. It doesn't have to do with any of the substantive claims brought by Terence Crawford. And just to remind you guys, the lawsuit was brought by Crawford alleging essentially a contract issue, that he was not given the appropriate amount of fights during a certain period of time, as well as the allegation that that he was to receive payments for a particular fight, and that didn't happen. We went over that in the video related to that. The issue here is where the lawsuit should be heard. So Top Rank here, going back to procedural issues, is indicating that there is a diversity jurisdiction issue here, and that supersedes any other kind of arguments that Terence Crawford is making. Again, Top Rank is in Nevada. Terence Crawford is a resident of the state of Nebraska. So there it is. That should do it, as well as the fact that he's asking for an amount over the jurisdictional limit of $75,000. The alleged breach of contract claim is no less than $4.5 million. So there you go. So that's the first issue. Very easy, at least from Top Rank's point of view. The second issue relates to whether or not a forum defendant could defeat the court's diversity jurisdiction. Now here again, we talk a little bit about whether or not Top Rank's removal was proper, and Crawford brings up the issue that this is a case of snap removal. What happens in snap removal is that a party automatically removes the case before any evaluation of the claims. And that's the policy behind not allowing that to happen. There are cases in this particular jurisdiction which don't allow that to happen. What in this particular issue, as we go back, Top Rank was notified of the lawsuit. They were sued, lawsuit filed, but not properly served yet. And that is therein lies the issue of SNAP jurisdiction, is whether or not you can be sued but not served, but still move the court to remove the case out of state court to federal court. And so in Top Rank's papers opposing the motion to remand, they indicate that multiple courts have recognized removal by a forum defendant who had been sued but not served, relying on a plain language interpretation of the state's text. So they go over these cases and similar that are in Top Rank's favor, indicating that sure, we can do these things swiftly, moving the case along. You could be sued, being notified of being sued, and in this case, attached to the paperwork is the email from a New York Post reporter asking Bob Arum for a comment before they were actually served with a lawsuit. Being served with a lawsuit means that the official person in charge of Top Rank, maybe not Bob Arum, usually the registered agent, receives the lawsuit. And when they receive the lawsuit, there is a certificate of service by the process server, and that is filed with the court. So they're indicating here that there is case law which allows for them to move the case to federal court, even though that particular certificate has not been filed. And so there's that argument they brought here. They indicate that Terence Crawford did not cite any cases that were opposed to the removal of by a forum defendant in that particular area. So, and then we go back into the issue of SNAP removal. And so in the Top Rank states that they are aware that the court has ruled SNAP removal is improper, resulting in an intra-district split on the question. So intra-district deals with different districts around the United States, but we particularly deal with the Ninth Circuit. And in this particular case, they say that this is not a case of SNAP removal, which the Ninth Circuit opposes. And so perhaps they state in their papers, finally, perhaps the driving force behind this court's prior decisions concerning SNAP removal is the assessment that SNAP removal allows well-resourced defendants to game the system by removing before the plaintiffs had a reasonable opportunity to serve the complaint. Yet, so there is the issue, an issue of judicial efficiency versus gaming the system and allowing a plaintiff to spend unnecessary money when they serve the case, and then the defendants go ahead and move the case to federal court. So there is that issue. So the Top Rank identifies all of these issues in opposing the case is remanded back to state court. Now, Terence Crawford's attorneys have filed a reply to their opposition, and here is what they say. Crawford's attorneys focus on a couple things. First of all, they look to the Top Rank contract, which gives exclusive jurisdiction to the state of Nevada. Top Rank is a Nevada business, and they indicate that in the contract, it states that Top Rank consents to exclusive personal jurisdiction and venue in state court in Nevada. Very interesting, compelling argument by Crawford there. Now, with respect to the fact that they claim the issue of SNAP removal, they note that the defendant, Top Rank, presented no evidence that it first learned of Mr. Crawford's lawsuit from the media and not by other means. So we talked about the fact that a New York Post reporter emailed Bob Arum, and that's attached to their opposition to remand. And they had the lawsuit, the New York Post reporter, and that's when Bob Arum states in his declarations that when he received an email about the lawsuit. Now, Crawford's attorneys parse this out a little bit by stating that However, conspicuously absent from the supporting declarations of Mr. Hone, the attorney for Top Rank, and Mr. Arum, is any corresponding testimony about whether Top Rank first learned of and or obtained Mr. Crawford's complaint. Instead, Mr. Arum solely testifies that he received an email at 9:09 a.m. Pacific Standard Time on January 12, 2022 from the Page 6 reporter with a copy of Mr. Crawford's complaint asking for comment. The email is attached as an exhibit. The email does not indicate where Ms. Smith received Mr. Crawford's complaint. More importantly, neither Mr. Smith nor Mr. Arum testify in their declarations that they first received or became aware of Mr. Crawford's complaint solely from the New York Post or any other media source. That testimony is completely lacking. Clearly, what they are arguing to the court is not consistent with their actual testimony and supporting evidence. So, as you saw from that passage there that I just read, and you just saw, there is a parsing of this information as to when Top Rank actually received this information of the lawsuit. And this potentially is a contemplation of just moving the case to federal court when it was right for them. Now, is the inference that Crawford's camp is saying that Bob Arum knew about this before receiving the email from the reporter? Most likely. So we'll see what the court says about that particular issue. So to break it down for you here, Top Rank wants to move this case to federal court. Terence Crawford's side wants to keep it in state court before we ever get to the substantive issues. Perhaps the reason why Crawford wants it in state court is because if this is a jury trial, you would have people within the state of Nevada, Nevada residents dealing with the particular issues. And perhaps because of the state court rules, you get a more favorable result. The issue here, from Crawford's perspective, is that Top Rank already consents to state court jurisdiction in its contract with Bud Crawford. Yet they want to move the case to federal court. Crawford is trying to keep them in state court based upon the contract that they already had availed themselves to. So the issue is very interesting from the fact that here you have Top Rank wanting to keep all of its contracts within state court, but then once it gets sued, it wants to move to federal court. So these filings, the last filing actually occurred in March, so we should be getting an idea of what the court will be thinking about this case. Hopefully it's not as long as what we see in the UFC antitrust case. We probably will get a ruling in the next month or so, if not by the end of May. So we'll keep you posted. Jason Cruz, The Legal Submission, MMA Payout. Have a great day, guys.